Sorry, was late by 10 minutes.
My lord, in item number 7, I filed an additional affidavit. The same may kindly be called for.
7,
Yes, ma'am.
affidavit.
Additional affidavit. Only 2 documents could not be annexed, my lord.
Let's get it.
I am deeply obliged.
May I, Lordship? Your Lordship, I beg to mention item number 8
Yes,
on behalf of conducting counsel PD Nair.
8, item 8.
Yes, Your Lordship.
Yes,
Your Lordship, on the last occasion when this matter was listed, we prayed for adjournment and to be listed after 3 weeks, Your Lordship. But it is listed today, Your Lordship.
it's a bail matter.
No, admission, CRL,
Item 8.
item 8, yeah.
Okay, it's a criminal provision.
Yes.
Okay.
So the conducting counsel could not make it today, Your Lordship.
When we want?
It may be listed after 2 weeks, Your Lordship.
On the prayer of Mr. Jitalo.
L. Yonten.
On behalf of?
Conducting counsel PD Nair, Your Lordship.
Appearing on behalf of Mr. P.D. Nair, Land Council for the list this matter after 4 weeks.
2 weeks, Your Lordship.
4 weeks.
Published, Your Lordship.
May I please, Lordship?
Yes,
Lordship, I beg to mention item number 10.
3.
10 and 11.
Yes,
Lordship, this matter may be fixed on 27/8.
you are for?
I am for
Where is
the
that?
petitioner.
Saying for on 27, that may be fixed for disposal.
On 27 of this month.
27.
Yes.
Your Lordship, in this matter, Your Lordship we will be needing the TCR, Your Lordship. The matter has already been charged with it. However, on the first occasion, the TCR is not called for.
On the prayer of Land Council for the parties, list this matter on 27/08/2024. List of in the meantime. Not in the meantime. Please stop. Call for the trial court record.
Deeply.
Deeply obliged.
Yes.
My lord, this is the matter, my lord. Wherein, my lord, against the respondent.
Yes.
Disqualification hearing was supposed to help, but this has been, my lord, stayed by the court without the jurisdiction. So basically, before the lordship, the impugned order is the order passed by the Civil Judge Senior Division Daporijo without the jurisdiction.
Hmm.
Now, my lord, facts of the case, my lord may kindly come to the page number 23, my lord.
So which the impugned order? Which
My lord-
order you are challenging?
Impugned order in page number, my lord, 36, 33,
36.
start from.
36.
Start from 33, my lord.
Okay. Hmm.
This is the title sheet whereby, my lord, the hearing proceeding has been, my lord,
Yes.
extended. So by this, my lord, I'll take the lordship to the, despite of reading everything,
Hmm.
my lord may kindly come to the page number 35. 35. The second paragraph, my lord. The learned counsel submitted that if the arbitrary expulsion order and the application is acted upon and the disqualification proceeding is common against her under the appropriate acts, then it will be cause immense hardship to the applicant that would be able to approach the court. If she is disqualified under the above facts, the learned counsel reported section 7 of the Arunachal Pradesh Local Authorities Prohibition of Defection Acts 2003, which said that noting anything contained in the law and the no court shall have the jurisdiction in respect of the matter connected with the disqualification of the members under this act. In view of above, the learned counsel has prayed for the act granting ex parte interim injunction order, staying the operation of the impugned order expulsion. The learned counsel submitted that if the expulsion is not stayed, it would be cause irreparable loss to the applicant and applicant is a Jila Prashad, members of the 16 Gita Riva under 26 ST Assembly constituency, Jumporijo, and may develop scheme undergoing hard such and such. Upon hearing for the applicant and on perils, I find the prima facie to go on trial. Furthermore, the balance of convenience is also still in favor of the applicant, and if the expulsion order is not stayed and disqualification proceeding is initiated against her under the Act, and she would be able to approach this challenging the court.
No, issue was,
So
against the, regarding expulsion,
My-
the defection.
against the expulsion, this is challenge against the expulsion
Yes.
in the form of my lord, title suit.
Hmm.
Now, my lord, my contention is that this title suit was filed with a value of 1 lakh
It's okay.
only. Therefore, my lord, this,
No, I'm just saying, when you read this section 7 of, Defection Act.
my lord, these are pertaining to
You are
section
not
7.
concerned now. You are not concerned now.
My lord, I am not
It
concerned.
was misconceived. You have filed the against the expulsion only, not the disqualification.
Exactly, my lord.
Yes,
My lord, this respondent has filed against the expulsion, my lord.
yes.
So in this expulsion order has been stayed. Therefore, my lord, in consequence of staying the expulsion order, my lord, the proposed disqualification hearing has been, my lord, stayed. That cannot took place on the ground that the,
Where it is.
my lord, that is no dear, my lord, that was, my lord, hard. My lord, may kindly come to the page number. That was fixed, my lord.
Where is the disqualification?
This qualification is still, my lord, where, my lord,
Disqualification has been stayed.
no, my lord.
Then
This qualification has not been stayed because
expulsion has been stayed.
expulsion has been stayed, and in
You want
consequence of
that
eh,
you want to say that unless he or she is expelled, you cannot proceed with that
exactly, my lord, that is the member secretary is,
See,
my lord, not
expulsion, there is a
absent.
gray area, Supreme Court, there is judgment of the Supreme Court. It's subject to interpretation, I don't know, but then it's not the only ground. Expulsion may not be a ground also, cannot be treated as a ground also.
My lord,
for
that is there.
disqualification.
But because of this, my lord, this disqualification hearing cannot take place, my lord.
So where
The deputy commissioner who supposed to heard the disqualification is denied on the basis of this,
You are saying that without jurisdiction,
without jurisdiction, my lord.
okay.
So, my
So,
lord, this
Then
is
this is pending now before the civil judge, senior division.
now when civil judge senior division come to know that, my lord,
Yes,
despite of returning the plain to the plaintiff,
yes,
this has been transferred to, my lord, civil judge junior division.
okay,
So that transport order is also being challenged before the lordship.
okay.
Because when the order was passed, when when the,
Mr. C. Modi, Land Council for the petition. By this revision petition,
my lord,
the petitioner has challenged the order dated 24/05/2025. Put to challenge, huh? The order dated 24/05/2024, passed by the civil judge within bracket senior division, the Procedural, whereby the expulsion from the party of the respondent number,
sole respondent, my lord.
respondent has been
That is 2524.
stayed. Then transfer, you're challenging the transfer.
My lord. Transport to the,
The further challenge is the transfer of the application. No, what is that? Transfer of the, what is that? It's a suit.
transport to the civil judge junior
The
division.
transfer of the DRJ oblique PS number 06/2024. Filed by the respondent
My lord.
to the court of civil judge junior division
Junior division, the operator.
on having been on the ground that the civil judge No, not on the ground. Transfer, huh? To the Court of Civil Junior Division. As the Civil Judge Senior Division has no pecuniary jurisdiction. Mr. Next para. Mr. C. Modi, learned counsel for the petitioner, submits that the impugn order dated 24/05/24 passed by the Civil Judge Senior Division is beyond the jurisdiction. Mr. The further submits that thereafter transferring the title suit to a jurisdictional civil judge, single,
Junior,
civil judge, junior division is also paid as the same would not have been transferred, but could have been returned a claim to the respondent, public plaintiff. Therefore, it submits that both the impugn order dated 24/05/2024. And what is the transferring, what the order of transfer? Page 37,
my lord, transferring in page number 49.
29.
49, sir, my lord, 449. Despite that the application was filed for return payment.
24. Transferring the PRJ oblique PS number 606 of 2020 to the jurisdiction civil judge, junior division. Issue notice returnable within 3 weeks. We'll make it 2 weeks.
My lord,
2
and
weeks.
till then, my lord,
The petitioner to take steps for service of notice upon respondent, the sole respondent, by registered post with AD. Then in that case, make it 2 weeks. We'll consider.
my lord,
After
till then
2 weeks.
interim be considered, man. Interim be, my
We'll
lord,
see.
considered
We'll
as
hear-
6 days.
Hear her or hear him?
What?
Hear her.
Otherwise, my lord, the
After-
next date is supposed to hard on 7/8/24. So, my lord,
Have
and
your this thing has been disposed of application. Simply transfer.
simply transfer, my lord. What my contention was, this should be returned, the plan should have been returned to the, despite of the transfer, this should have been returned. So while returning, my lord, the interim order which was passed without jurisdiction shall not be enforcement. So this interim order without jurisdiction is, my lord, blocking the further proceeding. So, my lord, till next returnable that the impugn order be stayed, my lord. Yes, my lord, it needless to submit that the order without jurisdiction of the any court, my lord, is null and void. So that's not enforceable, but now this instant impugn order is being blocked to the further proceeding.
Heard of the interim prayer. Next paragraph. Considering that the learned civil judge senior division parenthesis has exceeded its jurisdiction by passing the impugn order dated 24/05/2024 and transferring the title suit DRJ oblique title suit being DRJ oblique TS number 0224 dated 24 by order dated 24/07/2024 transfer. Not in violation of the provisions of Order 7 Rule 10 of CPC till the return of the both the impugn order itself remain staged.
Oh.
Yes,
My lord, this is my lord, the petitioner, my lord, this has been transferred.
you have 5 months to go.
My lord,
Yes, madam,
Yes, Your
why?
Lordship. Your Lordship, at this stage, Your Lordship, notice may be issued, Your Lordship. Notice may be issued. By that time, we will, bring our records.
Just will state this.
My lord.
Yes, that is
Learned counsel for the petitioner. By filing this writ petition, petitioner has put to challenge the transfer order. Where you do the transfer?
Transfer order at my lord, page 25, my lord.
Impugn.
Yes, impugn 25, my lord. Modify order, my lord. Last paragraph, my lord.
25,
Yes, modified.
page 25.
Yes, my lord.
Huh? Okay. Impugn
Last
order
paragraph.
dated 29/07/2024. By modifying the, by modifying the crossover order dated 17/07/2024, whereby the petitioner is sought to be, where you
My
are,
lord, I was retained there at Nari division till my superannuation on
Yes.
31st, my lord. This has been,
no, now where you are sought to be transferred.
my lord, only central zone, my lord.
Whereby
Yes, chief engineer central
petitioner
zone B.
is sought to be transferred from, what is this, Nari
division, my lord.
PWD division to Central Zone B
Yes, my lord.
at Itanagar.
Yes, my lord.
Mr.
Pasigat, my lord.
Pasigar.
Yes, ma'am.
Just nearby. What's that?
Central zone B, my lord.
Yes, Central Zone B,
Pasigat, my lord.
Pasigar. It's just nearby. What's the
My lord,
problem?
my lord, the problem is, my lord, I have already initiated my pension paper at the Nari division, my lord.
It is contended that the petitioner, the authorities has issued a common transfer order by order that is 17/07/2024, whereby the petitioner, considering that the petitioner
Serial number
order
11, my lord.
merger retirement within 5 months, 6 months, he was allowed to continue till his retirement. However, by a modification of the transfer order dated 17/07/2024. Now the respondent was the impugn order arbitrarily and directed the respondent number, which
Three, my lord.
respondent number 3 has been
May I please to your lordship?
Given, respondent number 3 has been allowed to take over the charge of the,
Your lordship, other,
charge of the Nari PWD division.
your lordship, otherwise, your lordship, there is nothing which shows that the petitioner is,
Issue notice
subordinating it.
returnable by 4 weeks.
Your lordship, petitioner, your lordship,
MS,
may I leave?
Sangeeta, London, London State Council enters appearance
Order number 3, your
and accepted notice on behalf
one
of
and
the
two
state
each.
respondents. No formal notice need be served, but however, extra copies we furnished to the London State Council within 2 days. Next para, the petitioner to take steps for service of notice upon respondent number 3 by registered post within 2 days from today. Mr. 2 days or 3 days?
3 days, man.
3 days from today. Next para.
For what?
Next para, considering that the petitioner is going to retire within a period of is going to retire after 5 months. And by order dated 17/07/2024, he was allowed to continue till his retirement. Till the returnable that the impute order shall remain state. This after 3 weeks. Yes,
Lordship, there is nothing which shows that petitioner is, subordinating in the, January 2025, lordship. They have not annexed anything, your lordship.
January 2025.
Yes, as they have claimed that they are,
Are
The
you
petitioner-
disputing that he is not retiring?
yes, your lordship.
Are you disputing that he is not retiring in
No,
January?
it's not there in.
It's on, what will say.
It's on the record, my lord.
Yes.
Yeah, it's there.
Next.
Lordship.
Yes,
Your lordship here,
yes.
that the competent authority allowed me a plot of land at native here in the year 1990.
Mr.
Titakur,
T. Thakur,
Yes.
learned counsel for the petitioner. By filing this application, petitioner has sought for a direction to the state respondents, particularly respondent number 3, to take up the complaint dated 05/09/2023 filed by the petitioner. Mr. Issue notice returnable by 4 weeks. Is there a private respondent?
yes, yes.
Miss MSG at the Learned additional senior government appears for and enters appearance and accepted notice on behalf of respondent 1, 2, and 3. No formal notice need be served. I have extra copies this on this range. Same. The petitioner to take a step for service of notice upon respondent number 4 by registered post.
Your lordship, filing a present
This after
petition,
4 weeks.
your lordship, filing a present
You have
petition
filed the
shall
application.
not be barred to,
It's been, it's a 2 years, 3 years.
no, your lordship. 10 months only. 10 months only.
10 months. Wait for another 4 weeks. We'll see.
Your lordship, in the meantime, filing a present petition shall be not be barred to,
The pendency of the present writ petition shall
To take
not
up-
be a bar for the respondent to, respondent number 3 to dispose of the representation.
your lordship. Much of, that's all. That's all.
Okay.
Much of.
If it is disposed, your main relief is redress.
Your lordship.
Had it been, had you allowed Mr. Titi Tara to appear, I
No,
would
no,
have dismissed your writ petition.
no, lordship.
It's because of you I am receiving notice.
Lordship,
All right.
lordship.
Yes.
Legislative also. The lordship, the present writ has been filed
As my rights were violated, your lordship. As I have
Yes.
already. Your lordship, the present writ has been filed as against the respondent number 1 to 4, your lordship, who are
It's a dispute between you and the respondent number 5.
it is a dispute between me and respondent number 5, your lordship.
Yes,
But
then
the
go to
respondent,
civil court.
but the respondent number 2 to 4, after serving them notices.
You are agreed by the payment of the amount
Yes,
in
your
the
lordship,
account of
which has been
respondent
credited.
number 5.
Yes, your
You
lordship.
go civil court.
Your lordship, there is a small submission, lordship, because this is the amount which has to be received. And there are some more amounts which has to be, because this is a contract which has been allotted to us.
It's a contract
Yes, your lordship.
and the dispute is in between you and respondent number 5.
Yes, your
Your
lordship.
main grievance, you are agreed by the payment of depositing of amount which was supposed to be deposited in your account,
Not my account, your
escrow
lordship.
account.
Escrow account, your lordship.
So it's a dispute between you and respondent.
No, your lordship,
By-
the account, the payment has to be done in the escrow account, for which we have already issued a notice also. Let your lordship, the respondent number 2 to 4 has to deposit, because it is a jointly allotted, your lordship. Your lordship,
You ask him to share, get your share. That's all.
your lordship, the respondent number 2 to 4 has to deposit in the escrow account, because the contract was done between us, respondent number 4 and respondent number 5. Kindly the
Add
lecture for
Mr. Your name,
Wasiuddin. Wasi.
Joseph.
VASEE.
Learned counsel for the petitioner.
Respondent number 2 to 4, Mala, I'm representing.
Just wait,
Standing counsel to the
Just wait.
health department.
just wait. By next para, by filing this writ petition, the petitioner has basically the petitioner, being aggrieved by the remittance of payable bills amount into the sole entity of respondent number 5 instead of remitting it to escrow account has sought for a direction to remit the further payable bills into the escrow account maintained by petitioner and respondent number 5. And also for a direction to the respondent number 5 for remittance of already remitted bills amount into a escrow account in terms of the conditional contemplation of the shareholding agreed in between the parties. Please come. Next. Having considered that the basic grievance is with the private respondent number. No, having considered the submissions and the materials and submission of the learned counsel for the parties for learned counsel for the petitioner, this court prima facie finds that the grievance is basically against the respondent number 5, which the writ petition may not lie.
Your-
List of. Though it is noted that though the petitioner has sought for remittance of the remaining amount in the escrow account. No, though the petitioner has sought for a direction to the state respondents for remittance of the remaining
Yes,
payable bills
yes, sir.
in the escrow account, such incidental such prayer seems to be an incidental. List of accordingly, the prima facie, this court is of the view that the this petition would not be maintainable. Please, however, before issuing a notice to the respondents, this court would grant the learned counsel but petitioner to satisfy the maintainability of this writ petition. List the matter after a week. After 1 week, you argue on maintainability. You show us any obligation on the part of
Maybe
the
posted
state
after 3 weeks, Your Lordship, because
not 3 weeks. After a week.
Because-
After a week.
because I have to come from Telangana, Your Lordship. That's the reason.
Yes,
I have to come from Telangana.
it's okay. It's now
Because I have to adjust.
you are not coming by foot?
I have to adjust my time.
Obviously, by air. Don't
Yes,
worry.
yes.
We'll hear you. If you satisfy, because today this court is a little
Yes. Okay.
tight, so I would have heard you. All right.
Much appreciated.
Yes.
Your Lordship. Your Lordship, may I please take your Lordship to page number 12?
Yes. University is not under the government. Is not it?
It is,
Is it under the government?
It's only one issue because I'm seeking clarification from Air Department. We are the chancellor.
That university is not under the government.
Is my understanding.
Yes.
your Lordship,
But
that
when
is,
I see the Lordship, the definitions of subordinate services, section 2, to all. It includes the autonomous body also,
Okay.
but it must be constituted under the government. Government of Arunachal Pradesh.
Yes.
Now question is whether this university is constituted.
This is which university?
Arunachal Pradesh University, Pasigat. And it is a state university, your Lordship. It's not a private university. It's a state university. And even the vice chancellor, he is also appointed by the secretary.
We'll see on next date. We'll see on next date.
Well,
According to you, the acts includes, will also, I mean, regulates the autonomous of the autonomous body
Constituted by the government.
constituted
of
by the,
Arunachal Pradesh.
then it will definitely,
Then whether this university, because the face of this university, how it comes under this purview of this definition. I'll take instruction and
in this
maybe
case,
the next date.
your Lordship, in this case, I pray that the examination may be state. The examination to the group C post, it may be state till next date, your Lordship. Otherwise, the very purpose of,
that may be considered on next date also.
because your
Then-
Lordship,
Then we'll consider it on 8. All right,
Can it be on,
this is 9.
Monday, your Lordship.
because I saw instruction till 10 also. Then
No, this exam will be on 9.
for 9.
According to the petition, it will be on 9.
Okay. Okay, then it may be listed on 8 also.
8. Will
Your
8
Lordship, on Monday, it will be more appropriate.
huh?
If it is hard on Monday, it will be more appropriate.
No, 8 will take it. Heard Mr. K. Tada, learned counsel for the petition. The Arunachal Pradesh, it's Arunachal Pradesh University or Arunachal University?
This is Arunachal Pradesh University.
Arunachal Pradesh University published an advertisement on 19/01/2024 inviting application for filling up of the various posts, various 41, various categories of posts, 41 in numbers.
Total is 48, your Lordship.
Huh?
Total is 48. But I'm challenging only the 41 numbers.
Various categories of post list of. The advertisement includes 41 numbers of vacant posts in the category of Group C, such as personal assistant, UDC, LDC, driver, and MTS. List of the process, the examination, written examination, is it?
Yes, sir.
The written examination is said to be scheduled on 09/08/2024. Next one. The learned counsel for the petitioner submits that the Arunachal Pradesh University is not the competent authority to conduct such recruitment for the post of for the Group C post. List of the competent authority is the Arunachal Pradesh State Staff Selection Board. List of therefore he submits that the direction be issued to the Arunachal Pradesh University to send requisition to the Arunachal Pradesh Public State Selection Board for recruitment of the above advertised post, as the Arunachal University is not the competent authority. Issue notice. No. List the matter on 08/08/2024. List of the no, not list the matter. The learned Mr. Estafin Learned Senior Government Advocate is directed to obtain instruction, particular as to whether the Arunachal Pradesh University is an autonomous body constituted by the government of Arunachal Pradesh or not. List the matter for further consideration on not further. List the matter for consideration on 08/08/2024. If it is falls under that, if it's been constituted by the state government, you may be correct. If it's purely autonomous, not constituted by the state. Dismiss.
It is by the state, Your Lordship. Thank you, Your Lordship.
Yes.
May I please?
Yes.
Your Lordship. My lord, I have limited prayer, my lord.
Yes.
My representation may be considered, maybe disposed of considering the education policy, my lord. Education policy of section, clause 9, subclause 16.
Sir,
Very,
this-
very, very
sir,
says,
this court doesn't believe in direction to dispose of the representation.
my lord, I have filed a representation to the concerned
Is
authority.
it a violation of the rules?
Yes, my lord.
Is it a violation? Which
Police,
rule-
policies,
which
my
the
lord.
rules?
Rules, my lord, policy is in my lord, is in page 30, my lord.
30.
Yeah, 30. It start from,
Just give the relevant.
it start from 25, page 25. So I will go to relevant is page 30.
25 is, what rule is this?
30, page 30, last
The
clause.
policy will be called the Teachers Transparent Posting Policy 2019-20. Yes.
Yes, my lord. Page 30.
Yes.
Page 30, last,
Teachers having 24 months.
yes.
Yes.
Teachers having 24 months or less than that before
Heard
retirement.
Mr. Esmo, learned counsel for the petitioner. By filing this application, writ application, the petitioner had challenged the, where is the impugn order?
My lord, impugn order is in page 24.
24.
24.
Has put to challenge the order dated 11/07/2024, whereby the petitioner is sought to be transferred from GSS comma, Soha to GUPS capital, comma, Canon. As trained graduate teacher. On the ground that same violates the clause within bracket, bracket, within bracket, Roman 16.
Yes.
Madam,
16.
Clause
That's right.
9 of
Roman 16.
Clause 9 of Roman
clause 9
16.
of Roman subclause.
Clause
Subclause.
9 of
Subclause.
clause 9 within bracket Roman 16, of the teachers transfer and posting policy, comma, 2019-2020 within bracket education. Bracket close. It is contended that the petitioner who is working as a trained
TGT,
graduate teacher
teacher.
was last posted at what is that?
Soha,
GSS, comma,
GSS,
Soha.
Government Higher Secondary School, yes, so.
On when?
It's for long time, my lord. That is not clear, madam, when he was
Soha,
appointed.
and now, please stop. The petitioner is on the verge of retirement within
Within 18 months.
18 months. Please stop. It is the contention of the learned counsel for the petitioner that the appeal order is in violation of the opposite policy, sorry, what is that? Teachers transfer and posting policy, 2019-2020, whereby it provides that the teachers having 24 months or less than that before retirement shall generally not be transferred, though they have completed their 5 years in the same school, as it may otherwise affect the preparation of their pension papers, etc., unless the teachers himself has sought transfer. Next, issue notice returnable by 4 weeks. Mr. T. Tagum, learned counsel for the learned standing counsel, enters appearance and accepted notice on behalf of respondent number 1, 2,
4, man.
1, 2, 3, and 4. Where is this private respondent?
In fact, we were seeking only the disposal of representation. That's what, even in our representation also, we have showed that we should be the representation to be disposed of considering the policy, my lord, considering the health and then the superannuation, my lord. So that's why we have not specifically made the respondent the party, my lord. So your lordship may dispose of.
I have no time. That's the reason. What do you say?
Malad, without pleading, that is the fatal malad. Affected party.
Okay, then what is your submission for disposal?
Malad, disposal, malad, that can be done, malad, but we have no.
List of, then you just delete the Mr. Tita. The before that, you delete whatever Tita. Miss the petition, learned counsel for the petitioner. Press that the petitioner has filed representation.
It's page 36, my lord. 36, 37, 38, my lord.
Filed representation before the competent authority, appropriate authority. For reconsideration, he transfer order and for granting home posting choice in GPS or GUPS within Devali town on superannuation ground. Yes. Therefore, however, the same has not been considered and disposed of. Therefore, he praised that the authorities, the Secretary of Education, Government of Varanasi may be directed to dispose of his representation dated 16/07/2024. Then next paragraph. Mr. T. Tagore, Learned Standing Council for Education Department, representing the respondent number 1, 2, 3, and 4. Fairly submits that he would not, he has no objection if if the writ petition is disposed of with a direction to dispose of the representation that is 16/07/2024 passed by the issued by filed by the submitted by the petitioner expert. Having considered that the limit prayer, and also considering that the teachers transfer and posting policy 2019/2020
Clause 9 and sub clause 16.
issued by notified by 10/02/2020 by the Department of Education provides provides that teachers having 24 months or less than that before retirement shall generally not be transferred, though they have completed their 5 years in same school, as it may otherwise affect the preparation of their pension papers, etc. Unless the teachers herself, himself has sought transfer. I deem it appropriate to dispose of this writ petition with a direction to the respondent number 2. I, Secretary Education, Government of Arunachal Pradesh, to dispose of the to take up the representation dated. Where it is representation?
36, my lord. 36, 37, 38.
The representation filed by the petitioner dated 16/07/2024.
And 15 to the director, my lord.
2024. In accordance with the applicable guidelines. Accordingly, the writ petition stands disposed of. The present, accordingly, the writ petition is disposed of with a direction to the respondent to consider and dispose of the representation of filed by the petitioner. That is 16/07/2024 within a period of 1 month from today. From today, 1 month or 15 days.
15 days, my lord.
And then period of 15 days from today.
On receipt of certified copy.
From the date of receipt of certified copy. 15 days, huh?
Till then, impugn order may be.
That is the problem. Status quo.
Till this, okay.
Status quo.
Till disposal.
Status quo.
Also, no.
Till the disposal of the writ petition. Representation. Status quo agent to this shall be maintained.
Declarable.
All right.
Yes.
Made this one. My lord, in this case, my lord, the respondent number 6 was the owner of a land measuring 540 square feet Now, my lord, in the year 2010, he has entered into agreement with the present petitioner that he will sell each floor to each of these, my lord, each flat to each of these petitioners, my lord. Accordingly, my lord, the petitioners paid money. Some sale deeds were also executed. Thereafter, my lord, in the year 2018,
No, wrongly or rightly, you may be prejudiced, but then the property has been mortgaged.
no, my lord, that is precisely, my lord, because my lord will kindly appreciate before taking into mortgage, the bank does independent inquiry regarding the title and ownership of the property. Here is a case when we were in possession of the property, my lord, the bank, because of their lackadaisical approach, my lord, they did not inquire properly, and my lord, they had taken this property into mortgage, knowing fully well that it has been sold, third party right has been created, and that, my lord, we were in possession of the said property. My lord will appreciate one thing, my lord, the respondent number 6, because we sent legal notice both to the bank as well as the respondent number 6, my lord. The respondent number 6 thereafter
And
when
Mr. M. Biswas, learned counsel for the petitioner. By filing this application, the petitioner, one,
petitioners,
all
all my
petitioners being aggrieved of the position notice dated 03/01/2024. Where is that position notice?
page number 67.
67. This is to whom?
My lord, this is to the borrower, my lord. This is a notice, possession notice.
It's not to you.
No, it is in general a possession notice.
It is not addressed to you.
No, my lord, at any moment, because once this possession notice is in the public domain, my lord, at any point of time,
Possession notice.
yes. Dated, my lord will see dated 3/1/2024. On the left hand side bottom.
How you are aggrieved? This is to the borrower, not to you.
My lord, the property in question is where I am, my lord, that is the issue, my lord, because the property in question is is my property. This possession notice is in respect to a property where, my lord, we are staying with our families.
It's up to you.
So if they take my
The fault
property,
is the borrower. If he has mortgaged this property,
but
to
he
the
has,
bank.
my lord, he has mortgaged it after he has sold it to us.
That is, he has played a fraud with you.
Absolutely, but the bank would have been
That the
diligent.
property is there.
My lord, the property is there, but now he has offered an alternative property. Now, that is my precise
Then
grievance.
after the bank to
Now, my
decide.
lord, the bank would have been diligent enough because, my lord, there is a system. My lord will kindly appreciate, my lord, because the bank most mechanically without
I
inquiry.
thought something else. This surface, and this surface only.
No, my lord, surface will not come against me because neither I am the borrower nor I am the guarantor. So, my lord, therefore I am saying, my lord, this possession notice they may
Fraudulently or whatever, maybe he had played a fraud on you, or maybe the bank, but the bank, if the bank is, can, the access to the property.
No, my lord,
It's
now,
a
now, my lord,
process.
what would, my lord, will kindly bear with me for a few seconds, my lord. Now, my lord, once an application for loan is made, my lord, the process in bank is that if a property is given as a mortgage, they initiate an independent inquiry regarding the right title and
How
income.
do we know now? How do we know that has not been done?
My lord, if that had been done, then how come this property they take on mortgage? Because I will show from record that this property has already been encumbered with us. This is not a property which is free from encumbrance.
Then go to because go to civil court.
Well, civil court claiming because my lord,
And you may file also a criminal complaint.
my lord, criminal complaint will not,
Initiate a criminal case also.
my lord, criminal complaint will not entitle me a right over my property, right to stay over my property.
Go to civil court.
My lord, my limited prayer is this, my lord, subject to what your lordship says, that my lord will kindly come to one annexure, my lord, I'll just show. Application, page number
We'll
68.
see. We'll just give, you take Dusty. We'll consider after 2 weeks.
My lord, my only limited prayer would be,
And Mr. M. Biswas, learned counsel for the petitioner. Petitioners. And what was that? Yes, 67. no? Way back. The property mortgaged by, is a party here?
yes, I made him a part.
Who?
The other guy who has done all this mischief, respondent number 6.
Respondent number 6. What is this? Last. Property belongs to the petitioners, which has been purchased from the borrower. I responded number 6.
The petitioner purchased from respondent number 6.
That is what I have said. Which had been mortgaged is sought to be, is sought to be under possession of the respondent bank. Is it?
Yeah, possession notice has been issued, but my lord, they have not taken physical possession. We are inhabitant of this place. It is under our possession.
No, that's what I'm saying. We put under the possession of the respondent bank. The respondent number 1. The respondent bank. It is contended by the learned counsel for the petitioners that the respondent bank ought to have what they're supposed
Have to have exercised diligence.
ought to have exercised diligence when the property in question was put on mortgage, placed on mortgage by the respondent number 6. As the property in question was already
Encumbered to the
encumbered
petitioner, in favor of the petitioner.
in favor of the petitioners. Not convinced, but then for a time being, we'll just see. Issue notice returnable by 4 weeks, 3 weeks. The petitioners to take steps for service of notice upon respondent. All the respondents,
All the respondents.
are you appearing? No. All the respondents within 3 days by register for so and so, huh? Till the returnable date. No, next. This thing. Considering that the property in question was already encumbered in favor of the petitioners before the same was put on, placed on mortgage before the respondent bank by the respondent number 6. And it is stated to be under the
Physical possession.
physical position of the petitioners with their family,
Absolutely,
with their families.
absolutely.
Come on, till the returnable debt. It is provided that, but no coercive action shall be initiated by the respondent bank.
My lord, I'm so grateful, my lord. Pendency of this petition may not be a bar for considering the application at page 68, because at page 68 an application is made by this.
It is provided that the pendency of the pendency of the writ petition shall not be a bar to consider
The representation dated,
representation filed by the petitioners.
no, filed by the respondent number 6.
We're not here for this respondent 6. Then leave it. Leave it.
I'm deeply aware.
Why you should plead for respondent number 6?
No, because he is asking for,
Or else you
Okay.
make him a petitioner.
I'm deeply aware.
Yes. What is to be done?
Your lordship can dispose this matter on merit if the LCR has come, your lordship, otherwise.
Huh?
Your lordship can also look into the LCR and can dispose of this matter otherwise on
So
merit.
then if the petitioner is not interested, we'll take it after some other thing. You have the records?
Your lordship,
Let us see next week.
charge sheet has already been filed, therefore.
Let's
the-
see next week. On non-appears for the petitioner on call, list the matter. No, after a week.
After a week.
After a week.
Deep-
Madam, just now I received that copy, counter affidavit filed by the respondent, madam.
7 and 9.
Yes,
7
ma'am.
and 9.
Yes, ma'am.
You have already filed.
Yes. So I'll be need some more time to file counter affidavit because I have to go through the affidavit they have filed just now, private respondent.
There's no
2 weeks.
stay.
Well, there's no stage.
Work is already about.
Okay, then we'll fix after 6 weeks.
Madam,
Yes.
madam, let it be after 2 weeks, madam. Because
And Mr. T. Tagum, learned counsel for the petition. Also had Mr.
1 to 6.
Is learned student counsel for respondent number 1 to 6. And also Mr. PJ learned senior counsel assisted by P. Bodole. For respondent 7 and 9.
No, only 7.
What about 9?
9 may not be
That-
for now since
Because he
the,
has not been, 8 and 9 has not been given, has not been awarded. Only 7, the work has been awarded to respondent number 7.
my lord, that may be the reason why they are, because earlier,
Non appears for respondent number 7. Non appears for respondent number 8 and 9. We'll see. Mr. T. Tagum, on the prayer of Mr. T. Tagum, learned counsel for the petitioner submits that he has received, he has been furnished with the counter affidavit filed by the respondent number today.
yes,
Therefore, he prays for,
has already filed.
huh?
just now.
Has already
filed.
filed. I have filed today. We have filed.
Respondent number 7
Yes, 7,
today. Therefore, he
Within
prays
7
for listing the matter after 2 weeks.
my lord.
Prayer is allowed, list after 2 weeks. Just give the date, whatever. After 2 weeks. Yes. Next.
27/8.
37.
Yes.
I'll file my reply today.
Filing.
Affidavit, yes.
You are
I
filing,
have served the copy this morning,
you are filing today.
yes.
or Mr. Elper Melan,
Hello,
counsel for the petitioner. You are for
I'm for private respondent number 5, 6, 7, and 8, my lord.
5, 6, what about 11, 12?
11, 12 also I have effected service and effected to Dusty, my lord. I have filed affidavit to district.
Mr.
Mr.
So-and-so
T.
appeared
Darge.
for respondent
Darge.
number? Respondent number
5, 6, 7, and 8.
5, 6, 7, and
And
8.
My lord, we have not filed the reply. We need some more time to file reply. 7, 8, 9, 10, 11 also I have my lord.
You've taken steps.
Yeah. I have already affected my lord. I have
The-
filed
the-
an affidavit, my lord.
Huh?
That I have filed an affidavit of Dusty, my lord.
That's the half. Mr. L. Permelan, counsel for the petitioner. No, before that, before it is
Respondent.
continue her so and so, Mr. L. Permelan, counsel for the petitioner, has filed an affidavit of justice service to the respondent number 5 to 11. 11,
11, my lord.
which is taken on record. Mr. The taken on record and accepted. Mr. So-and-so, then you read, then counsel entered appearance on of respondent number 5 to 8. Mr. The service of respondent number 9 to 11
9 to 11.
is complete list of the respondents. You are for MS.
For 3 and 4 lots.
G at the London Additional Senior Government Advocate and Mr. So-and-so for respondent number 5 to 8. Granted 2 weeks time.
My lord,
File affidavit.
in last occasion, my lord, there's an order, my lord, to consider my interim prayer today, my lord.
Hmm.
I have interim prayer, my lord. At least, my lord, I believe, my lord, status quo, my lord, in respect to the disputed land, my lord, is necessary, my lord. Otherwise, there, my lord, I have annexed a photo also, my lord, showing, my lord, they
What
are
do you say?
changing the demography of. So,
You are 3 and 4 in the state.
state, my lord.
State has nothing to do. It's basically a private thing.
LPC, issuing of LPC.
Okay, then
And
what do you say?
what we
You
have said
maintain
is-
status quo.
I don't have any option.
You have no objection.
Yeah.
Having considered the submissions of the learned counsel for the parties.
What we have said in our affidavit is that we have followed the.
It's okay, we'll see. It's a status quo, they are seeking for status. We'll see that. Learned counsel for the parties, particularly the
Respondent 5 to.
restaurant 5 to 8. Who has no objection to maintain status quo agent today.
My lord, I have objection, my lord.
The parties to maintain status quo agent today.
Status quo.
Status quo, what's here?
My lord.
He said, your junior has said he has no objection.
Status quo, no is. Otherwise, my
That's
lord,
all.
this
He
is a,
also say, he's not
My lord.
seeking.
otherwise, my lord, case disputed question of fact number one.
We'll see after 2 weeks.
After two.